On behalf of Specialty Care, I'd like to welcome everybody to this evening's phenomenal presentation by two renowned attorneys who are going to address a very germane topic that is affecting all of us. My name is Al Stammers. I'm the Vice President of Clinical Quality and Outcomes Research at Specialty Care in the Perfusion Service line. And this evening, my co-moderator is Dr. Cheryl Wiggins. Dr. Wiggins is the Vice President of Education and Clinical Performance in the Intraoperative Neuromonitoring Division of Specialty Care. So let's go ahead and begin with some background information, very similar to the 23 previous webinars that we've held so far. To receive Category 1 CEU credits from the American Board, please make sure you follow these two very basic buttons in regards to staying on the webinar. And then on the right-hand side, we see the 1.2 category credits that are being offered. You will be emailed a certificate within usually a week's time. If you do not receive that at the very last slide, we'll have Cheryl and my emails up there. Please get a hold of either of us and we'll make sure that you get it. And plus this presentation, like all of our presentations, can be found on YouTube. It'll be recorded, it is being recorded actually right now, and it will be up on YouTube within about a week's time. The survey is very simple to fill out, just 3 simple questions. And then on the right-hand side, you can see where the certificate will be coming to you from Gutenberg Certifications. So just a reminder, we have a question and answer session that will be at the end of the webinar presentation. So please use the functions that are in Zoom in regards to submitting your Q&As in that particular tab that's on the ribbon, should be at the bottom or the top of your screen. And as you see those questions entering, if you like it, go ahead and click on it and that will elevate it. The more clicks that particular question has, it elevates it to the top of the queue. So Cheryl and I can look at those, and of course we will also direct other questions that we may have to our panelists today. So with that, I'd like to begin with introductions by asking Dr. Wiggins to go ahead and introduce Christy Green.
Thanks so much, Al. So Christy Green is currently our deputy counsel here at Specialty Care, and before coming to us, she started her practice in Nashville at the law firm of Waller, Lansden, Dortch, and Davis, but has worked as an in-house lawyer for healthcare or regulated companies for almost 20 years. So we're excited to see her input in this presentation along with Debbie. So I'll let Al go next.
Thank you, Cheryl. And yes, and Debbie Weinrich is a partner in the law firm of White & Williams, specializing in the defense and medical malpractice lawsuits. Debbie is a graduate. She has a nursing degree that she got prior to becoming an attorney. She graduated from the Thomas Jefferson School of Nursing in 1993, and then received her JD from Rutgers University School of Law in 1994. She represents private healthcare companies as well as physicians and healthcare providers, including perfusionists and neuromonitoring specialists in lawsuits where they have been named. But she also represents long-term care facilities. In addition to her medical malpractice, she does general litigation, including construction, premises liability, and other matters. She has authored several papers that have been published in the Healthcare Alert, and in 2019 was honored with the Distinguished Advocate by the Support Center for Child Advocates for her pro bono service. So Debbie, thank you for joining us this evening as a panelist.
Thanks for having me.
Thank you. At this point, I'm going to shift over to Christy, and Christy will begin the presentation.
Okay, great. Hello, I'm Christy Green. Thank you, Al, for having me. I am located here in Nashville, Tennessee. I'm actually located just a few miles from Vanderbilt Medical Facility. So today, as you may know, we're going to talk about RaDonda Vaught, who got quite a bit of national publicity because she was charged and convicted after just making a human error, giving the wrong medication. And so that has made a lot of our clinicians nervous about, will my mistakes become criminal? So that's what we're going to talk about today. As a lawyer, I have to start with disclaimers. Debbie and I are not providing any legal advice today. If you have questions, specific issues, contact your counsel. We're not creating an attorney-client relationship here with any attendee. And of course, Specialty Care and White & Williams want you to know that any information, statements, opinions are those of Deborah or myself and not of Specialty Care or White & Williams. So just kind of an overview of what we'll do today is I'll give you a big overview of the case, which you probably all know. Then we'll talk about the elements of criminally negligent homicide and gross neglect of a vulnerable adult, which are what RaDonda Vaught was actually convicted of by a jury. Next, I'll go through the day the medical error occurred in the event. So we can all see from a sequential perspective what happened. Then I have a timeline because the actual medication event happened in 2017. However, she actually did not go to trial until March of 2022 and was sentenced in May of 2022, which was just a few months ago. There was a lot of response regarding her conviction, viewpoints. And then, you know, for this group, I thought it would be most relevant to talk about, you know, charging, convicting clinicians, and the effect that's going to have on our just culture, and encouraging people to come forward with mistakes so that we can understand and fix systematic problems and processes versus being punitive. Finally, and we'll just give a very high level overview. This is not the first case where a clinician has been criminally charged or convicted. There are a handful of cases. They happen every few years, and I believe they're very fact specific. And then there's a political element to it too, based on who the specific district attorney is. So let me start by providing you some background of the patient who unfortunately died prematurely. Her name was Charlene Murphy. She was 75. She did have a background of cancer, but she came to Vanderbilt December 24th, 2017 with a brain bleed. She was doing better, and on December 26th of 2017, the physician ordered a full body PET scan. Her nurse was not available, so Vaught, who was acting as a help all nurse on that day, was assigned the task of obtaining the medication Versed to help for anxiety. Unfortunately, Vaught, instead of Versed, acquired vecuronium bromide and administered that to Miss Murphy. Probably most clinicians know vecuronium is used for anesthetic purposes. It's a paralytic agent, and so it paralyzes the muscles, including the lungs. Therefore, at some point, Miss Murphy couldn't breathe. She was found not breathing. She was resuscitated, but brain dead, and so she died on December 27th, 2017. Who is RaDonda? Just a brief overview of her background. She was an RN in Tennessee and was licensed in 2015. And in 2015, she was also employed by Vanderbilt Medical Center. A few points about Vanderbilt for those of you who don't know. It is the largest hospital in Nashville. It's also the largest employer in Nashville. And of course, most of you know it's very renowned and a prestigious facility. So on December 26, 2017, on the date of the medical error, Vaught worked on Vanderbilt's neuro ICU unit. However, again, on this day, she was the help hall nurse. In addition to being the help hall nurse, she had a trainee or orientee. She was orienting a new nurse, but ultimately lost her medical license. She also was found guilty, again, of criminally negligent homicide and gross neglect of a vulnerable adult. She was sentenced, thankfully, most clinicians believe, to 3 years of probation. During the sentencing, the judge talked a lot about the negative result that would happen if she was sentenced to prison, if we started sending clinicians who made mistakes to jail. Vaught had a whole lot of nurses support her. Nurses came throughout the country during the trial, during the sentencing. Many of them could really relate to RaDonda and were very vocal about, they could easily be in her place, or they were one error away from being in her place. So, criminally negligent homicide in Tennessee. Of course, this is Tennessee. Different states will call it different things. In Tennessee, it used to be called involuntary manslaughter. In Tennessee, criminally negligent homicide is criminally negligent conduct that results in a death. And it's different from simple negligence in that there must be intent. And intent in this case is taking a substantial and justifiable risk and failing to perceive that it's a gross deviation from the standard of care that an ordinary person would exercise in those circumstances. Vaught was also convicted of gross neglect of a vulnerable adult. This statute was most likely put in place for nursing homes, care of the elderly, but in Tennessee, failure to supervise a vulnerable person can cause you to be convicted of gross neglect of a vulnerable adult. Debbie, do you want to talk just briefly? I'm going to go back. We talked about criminally negligent homicide, and I said it wasn't simple negligence. Do you want to give a little background about just negligence from a civil perspective?
Sure. Generally, negligence, as one would have in an ordinary medical malpractice case, or actually any tort, which is known in the law. But negligence from a medical malpractice perspective it's ABC. So we say A, duty. So you have a duty to the person so that it's your patient. That's how you fulfill that duty. Then B is there's a breach, and that's a breach of the standard of care. And in all states and all jurisdictions, generally you have experts who establish the standard of care. And then C stands for causation. Causation means there had to have been some harm based on your breach. And then D stands for damages. So what are the patient's damages? So harm was caused, and what's going to amount to their injuries? Are they permanent? Do they need a life care plan because they need lifetime care? Did they lose work? Has their earning capacity been diminished or lost? So those are the elements that you would go through. I don't know that we'll necessarily talk about it now. I think we'll wait until later, but there is also an element that's a little bit above ordinary negligence, and that is when they try to prove and obtain punitive damages. So that's a higher level, and we can talk about a little bit about that later. But in all honesty, you can sue somebody and obtain punitive damages, monetary damages, for a higher level of gross negligence or recklessness, wanton and willful behavior.
And I believe probably most of us here are used to medical negligence matters being handled in a civil arena versus criminal, which is, I believe, why this got so much coverage. Okay, so I do want to take everyone through the day of the medication error in the steps, so that everyone can form their own opinion regarding, what sort of actions should have been taken, regardless of what did happen. So before I start, I also want to let people know as background, in November of 2017, Vanderbilt was undergoing a conversion to Epic, which is an electronic health medical record system. And as part of this conversion to Epic, there was difficulty with the automatic medication dispensing system talking to the pharmacist or whatever the pharmacy system had. And testimony was that Vanderbilt's fix for these difficulties, the short-term fix, was to override the automatic medication dispensing system. So Vought was ordered or assigned to obtain Versed for Charlene Murphy. She went to their automatic dispensing systems called AccuDose. She went to AccuDose, pulled up Charlene's profile, and Versed was not listed there.
And Christy, just for those who may not be familiar with AccuDose, but may be familiar with another very commonly used system, it's Pyxis. So it's the machine that houses the drugs, and the clinician has to enter information into the computer successfully to get the drawer that holds the right medication to open. In case you're not familiar with that process, that's the basic description of what she was trying to do using the AccuDose.
Right, thank you. And so most hospitals' processes or procedures, if you pulled up a patient profile and the medication wasn't there that you thought was supposed to be there, she could have called the pharmacist, or she could have reached out to the physician. Instead, she began to override the system. Again, there was testimony that this was commonplace during this time at Vanderbilt, and as evidenced by that, Ms. Murphy actually received almost 24 medications during her stay at Vanderbilt from different nurses using the override system. And so part of her defense was warning fatigue. So first warning, pulled it up, it wasn't in the profile. So Vought begins her override of the system. What pops up? Override medication should only be accompanied by stat orders when a patient would be compromised by a delay. So in emergency situations, Vought read or did not read that, and she typed in VE. And VE brought up vecuronium bromide. So as it brought up vecuronium bromide, paralyzing agent was beside the name of the medication. She selects vecuronium bromide. Other warnings pop up. Paralyzing agent, causes respiratory arrest. Patient must be ventilated. She selects the quantity of the drug. Again, paralyzing agent, a yellow caution alert, a yellow caution sign appears. Vought testified that during this time, and I can see it, like if you're used to overriding a system, you're probably just pressing the screen buttons, not reading the warnings. In addition, Vought testified that her trainee was asking her questions while she went through this override process. So Vought probably most likely did have warning fatigue, probably did not read the warnings on these screens. But in addition to that, after she obtained the vecuronium, the prosecution argued that she should have noticed a number of red flags. So Vaught gets the vecuronium, goes to the patient who is in the radiology unit. She's able to check the patient's ID, but there's not a computer or scanner there for her to scan the medication. However, vecuronium comes in a powder form as opposed to a liquid. Versed is a liquid. Vaught had given Versed on numerous occasions. She did give him Versed the day before. It's a liquid. The cap on the bottle is red and says paralyzing agent. Vaught testified that she did have to read the instructions on the bottle to reconstitute the powder to a liquid form. So she read, kind of small instructions, but failed to look at the name of the drug. Again, she's reconstituting this. She's shaking the bottle. This is something she normally would not have had to do with Versed. Finally, to draw the dose, Vaught would have had to, again, look at the red cap of the bottle as she put the syringe in. There's a warning, paralyzing agent. And then after she administered the vecuronium, what she thought was Versed, Vaught and her trainee immediately left Miss Murphy alone. Had she stayed, had anyone stayed, they would have recognized, her respiratory distress, and they could have taken measures to save Miss Murphy at that point. From a timeline perspective, what ended up happening was about 30 minutes went by. She was alone. A transporter walked by, noticed she wasn't breathing. They had to resuscitate her. However, she was brain dead at that point. So I'm going to walk you through the timeline. We walked through the day of the medication error. Now I'm going to walk you through the timeline that took us from 2017 to March, the trial in 2022, and the May sentencing. So on the day of the medication error, Vaught testified that her supervisor advised her not to document the medical error in the record. So I've read that whoever the supervisor was thought that by the fact that she got the vecuronium from the AccuDose system, somehow this was going to show up in the patient's medical record. So this may not have been intent to cover up the error. But Vanderbilt did not report the error as is required by law. The next day, Ms. Murphy died. On January 3rd, just a few days later, Vanderbilt fired Vaught. They gave her a termination letter that said she failed to follow the 5 medication rights when you administer medication. And they said that they would report this to the Tennessee Board of Nursing. During the spring of 2018, Vanderbilt negotiated a confidential settlement with the family. So the family didn't file a lawsuit. They did hire an attorney quickly, and I'm sure instead of suits being filed, they just negotiated a settlement. In May of 2018, Vaught did find employment as a throughput coordinator at another facility in Nashville. This did require a nursing license, but had no clinical component. In October of 2018, someone anonymously, a whistleblower, alerted state and federal authorities of the unreported medication error. And by unreported, they're talking about Vanderbilt's failure to report. Oddly enough, close in time there too, like in October 2018, and this was without the without knowing the facts. All the Department of Health had at this time was the termination letter from Vaught. And at that time, the Board of Nursing decided not to pursue any action against Vaught.
So many details, so little time, so many details.
I know. But however, I think they're all important to make form an opinion. Anyway, so we have an anonymous tipster. CMS conducts a surprise visit to Vanderbilt, spend several days at Vanderbilt. They just review the facts around this case. Late in November, they issue a report and threaten to suspend Vanderbilt's Medicare payments, which is a severe punishment. It would have crippled Vanderbilt financially. CMS's report and Vanderbilt's response, which are both publicly available, are both helpful reads. CMS noted that the nurses failed to follow the procedures in place, that Vanderbilt's policies failed to require people to monitor patients after medications were given, failed to, there was a failure to document the transport when she arrived, failure to document the medication that was given, failure of the Quality Improvement Committee to make a record of discussing this matter and in the improvements they made from it. They probably discussed it, I imagine. There were probably improvements made, but there was no record of it for CMS to see. Most importantly, though, CMS noted that Vanderbilt failed to report the medication error as required by state law. So Vanderbilt issued a 105-page response to CMS, and
promising to fix everything. Everything.
It appeased CMS, or at least they got tired reading. I shouldn't say that. Tired reading the 105 pages. No, but they did put some very good policies in place. They were more pointed policies. You know, patients could not be left alone when they were being transported ever. Everything needed to be documented in the record. They had already made sure there was a computer system or scanner in the radiology area. But most importantly, and Vanderbilt's a big system. So, you know, there are lots of different committees and people. They made one designation spot, one designation office for reporting events like this. And then they had weekly meetings to make sure they didn't miss reporting something going forward. So after that happens, the Tennessee Bureau of Investigation interviews RaDonda. I'm not giving legal advice. However, if anyone reads you your Miranda rights ever, do not waive them. Insist on an attorney. RaDonda just feels bad. RaDonda will say, like, I killed a person. RaDonda's just like being honest, trying to give information. So she waives her rights, and the TBI interviews her and audio records the interview. You know, RaDonda says, it was all my fault. I should have double checked the medication. She said she became complacent and that she was distracted. You know, she said she never looked at the front of the vial. And she ends her interview with the TBI by saying, I effed up. I mean, that's the end of the interview. So shortly after the interview, she is charged with reckless homicide and impaired adult abuse. These are higher charges than she was ultimately convicted of. but she's charged shortly after the interview. So then in February of 2019, Vanderbilt has to go in front of the Tennessee Board of Licensing for Health Facilities. This is the first time Vanderbilt speaks, first and only time. They have taken the position since their settlement that it's confidential and they cannot say anything. But in the meeting with the licensing board, they admitted the death was not reported. They disclosed for the first time that they settled with the patient's family. Board takes no action against Vanderbilt. So Vaught was charged, board takes no action against Vanderbilt. Then to pile on to Vaught, the Board of Nursing decides to reverse its decision from 2018 and decides to pursue disciplinary proceedings against her. As we all know, then COVID happened. There was a long delay. However, these last two timeline events are of the utmost importance, because what happened is Vaught's disciplinary hearing with the Board of Nursing happened before her criminal trial. So what happened again is just like the TBI interview, Vaught went in front of this disciplinary board and told the story, all of which was able to be used against her at her criminal trial. The trial lasted 3 to 4 days, I think 3 days. Again, they found her guilty of criminally negligent homicide and gross neglect of a vulnerable adult. So in summary, which we've all talked about, the proof at trial was she struggled with the medication cabinet, didn't use it correctly. She didn't select a drug that was in the patient's medical record. She didn't reach out to the physician. She didn't reach out to the pharmacist. You know, she ignored all the warnings and all the red flags, which again, if you're a layperson, I know there are probably lots of clinicians listening, but as a layperson, if you saw all these warnings, you might not understand from a clinician's perspective, like how many warnings they see on a daily basis. She didn't report the medical error in the record. Didn't matter that she was told not to. And then because there was no record of it, the Davidson County Medical Examiner didn't do an investigation. So there was a lot of outrage after her conviction, and in between her conviction and the sentencing. Yeah, I've got quotes from the American Nurse Association, American Hospital Association. They're long quotes, but basically they're saying humans make errors, clinicians make errors. This is not the route to go. You know, we already have, especially in the nursing profession, we've already got burnout. We just had COVID, and now we're, you know, criminally convicting nurses for medical errors. The American Hospital Association, as I had said, you know, noted the chilling effect that this was going to have. People weren't going to be honest about mistakes. People weren't going to report things so that systems could be improved. So then, you know, again, there are two sides, two viewpoints you could take. The district attorney in Davidson County, I do believe this was a politically motivated charge of Vaught. He thought there were aggravated circumstances. He cited multiple system overrides, ignoring the packaging, and not reporting the medical record. As Deborah noted, you know, most medical errors are civil matters, and they're handled through, you know, monetary settlements.
Well, in addition to that, clinicians that hold licenses are subject to their board's discipline. So you're taking a clinician who, just like a layperson, is, subject to a lawsuit if you do something wrong and you harm somebody, whether you're doing it in a medical malpractice setting or not. But on top of that, you can be sued civilly. You can also be sued to include punitive damages if it's egregious behavior, wanton disregard for the safety of a patient or a human being. But on top of that, clinicians are subject to discipline by the board. So taking a clinician who can be sued civilly and can have their license suspended, discipline revoked, or taken away, and, in my opinion, I think that's ample opportunity for punishment, deterrence, and everything else. So to take it to the next level for criminal prosecution, that's the problem. Where this is the tension. This is why there's so much outrage.
Completely agree. So again, the concern is what effect is this going to have on healthcare systems who are trying to encourage reporting of medical errors so that we can fix the systems and not blame individuals.
Again, we're not giving legal advice, but as somebody who handles lawsuits all the time, I can tell you that the worst thing in the world you can do is try to cover up a mistake. If you don't own it and you try to cover it up, when it's found out, you are going to be held you're in much more danger. You're deeper in the pile, you're down the river without a paddle, as it were. You have to, whether your institution is the justice culture in the world or not, I'm telling you that it never helps. It always hurts.
You want to report and you want to document everything. You cannot document too much.
Well, you can. You can. You need to document appropriately, and you need to reach out to counsel and reach out to your managers and reach out to address to ensure that all the documentation on all the levels is done appropriately. Incident reports, variance reports, whatever your institution calls them, there are processes in place at your institutions. I guarantee it. So you need to make sure you go through that process and do it as soon as you're aware of the error and try to mitigate that error. So if you give the wrong medication, say, and you realize it, then you need to make somebody right away. Maybe there's an anecdote. Maybe they can give fluids. Maybe they can do something. So hiding it is the worst thing known to man. and that's going to put you at risk for civil and potentially criminal, depending on what's going on in the state or with the DA and the culture at the time where you are.
Right. And so just quickly, and then we'll go to the discussion. But as we said, there are a handful of other cases out there where different types of clinicians have been criminally charged, have pled to different charges, have been convicted or have been acquitted. But you look at the dates, it's like 1997, 2006, 2009, 2013, 2019, 2022. Of course, I'm sure we didn't find all the cases, but the point is it is not typical for a clinician who makes an honest error to be criminally charged or convicted.
But I think the main thing is as I've read these is, in my opinion, I don't see the utility in putting a clinician in jail for a mistake. I don't know why does the government want to spend the money to prosecute? Why do we want to spend the money to have someone in jail, especially if their license has been taken away? I just don't see how that's going to deter them from making further mistakes, medical mistakes. Now, again, we're not talking about Dr. Death here. I'm sure you've all heard of Dr. Death and we all know who he is. That's not what we're talking about here. We're talking about mistakes, just overwhelmed. Yes. Could it have been done better? Sure. We all know that, but I don't understand. And I guess it's, my personal take on it is, what's the utility in prosecuting these people? If it's just to try to make the family happy, it's not going to make them happy. It doesn't bring their loved ones back. And that's my personal soapbox on the criminal, the choice to do it criminally. And I represent clinicians in civil cases all the time, and believe me, they're wrecked by even being accused of negligence when there aren't even mistakes made, or there's just a bad outcome. So, and Christy and I have both read descriptions and statements by all of these practitioners, and they all live with horrible guilt. There's references and studies to the fact that the suicide rate is higher for people who make mistakes. These people aren't walking away scot-free. They're living with it for their lifetime, regardless of whether somebody wants to put them through a criminal trial.
Well, this is great. Christy and Debbie, thank you so much. There are loads of questions being asked, and I really want to thank you both for this great summarization and your personal experiences with your legal background. One quick thing before I ask Cheryl to go ahead and ask the Q&A. When I introduced Debbie, I said she graduated nursing school in '93 and law school in '94. She graduated law school in 2004. So she practiced for 10 years as a nurse. I think that's important that she didn't go right from, say, her nursing degree into law. She has experience in the clinical environment. So with that now, we've got a lot of questions to get to. I'm going to ask both Christy and Debbie if you can keep your answers short so we can get to as many of them as possible. And I know that you both have great experience in this and can talk for quite a while, but we'll try to get to as many as possible. So Cheryl, please go ahead.
Absolutely. Absolutely. And one of the questions that really struck me as well, and we can appreciate, Debbie, your clinical side as well, but when you're talking about folks like perfusionists, like nurses, people who are state licensed clinicians, how does that move in the realm when it comes to criminal court, when what you're looking for is a jury of their peers? Like, who are those peers on that jury making those decisions? Because it's sometimes projected overall as a benefit, but in this situation, it sounds like it maybe isn't a benefit for the way that it all came out.
Well, the nursing boards and the medical boards and stuff are comprised of clinicians. They, that's the body of your peers. The body of your peers in state court or even federal court, that's just peers who live in your jurisdiction. It's a mixed group. They don't have to be doctors. They don't have to be nurses. They don't have to be perfusionists. And in all honesty, when we pick juries, sometimes we don't want nurses on the jury, or sometimes we don't want a doctor on the jury. It's not necessarily a benefit or a hindrance. You just never know. But you don't get to have a jury of 12 of perfusionists.
Or even trial. Or even informed people, for that matter, as far as it goes.
You try to turn the cases to, the level of where you're smarter than the sixth grader or whatever the show is.
It does bring up other components of, like you said, like the level of fairness. Not that any of us get to consider this fair, right? But when it comes down to the multiple ways that you do feel kind of pressed by all of these matters, right? As you mentioned, civilly, criminally, also when it comes to your own licensure. And this brings up a follow-up question for me. So looking at all of those components, and you look at things like automated systems that may help the fatigue, the component, what is the best forum? And maybe Al, even your opinion on this, like, what is the best forum to make these decisions on the risk versus reward for when we depend on automated systems versus when we go back to the old fashioned method of looking at, true human oversight in that aspect?
I'll let you go first, Al. If you like.
Well, I'm going to shift it to Christy. So, Christy, I'd love to hear your thoughts on that, specifically on automation. Do we add an element with technology that actually is a step backwards?
Well, so interestingly enough, in this case, and I've heard with a couple of other systems, Vanderbilt specifically with their AccuDose system, first of all, removed vecuronium from the automatic dispensing system. In addition, because there are other paralyzing agents, they changed the system. So you have to type in PARA and then the drug name to have such a paralytic dispensed. in this case where the automatic system is not working, Vought did have, which I believe, again, I'm not a clinician, but would be a little bit more of the old-fashioned way of confirming with the physician or calling the pharmacist or using one of those routes. But not to say automation is any better, but they have tried to take that automation and make it a little bit safer.
Thank you, Christy. Christy, I'm going to follow up with a question for both you and Deb, and I apologize for asking the brevity here. You're both doing a wonderful job. The Department of Health in Tennessee reviewed this case and decided not to press charge or not to result in disciplinary action, as you pointed out. And Debbie had said medical boards, nurse boards, and others are out there. There's a lot of controversy with medical boards and nursing boards because you're basically, putting the fox in charge of the hen house. A lot of people believe, and it's actually published. Medical boards rarely impose disciplinary action on physicians and healthcare providers. So do you feel that there was a real breakdown here where, you have these entities that are supposed to oversee the health and welfare of patients, overseeing these practitioners, and they failed on multiple levels? And is that something that could be systemic in our clinical environment?
I'll go first. No system is perfect for policing these type of things. But the theory is, and there's something called peer review, which is based on, there's peer review protections in many states. And what that does is it fosters clinicians, doctors, to be able to go and discuss when something happens. They're able to discuss it. They're able to be self-critical. They're allowed to be critical of their peers. And that is to foster open communication so things can get fixed. So if the nursing boards are treated the same, if you think about it the same way, there's no confidentiality. It's all open, and they publish when they discipline people. So there's no perfect fix, but they do publish and they do discipline people. And there is quality controls and risk management in most institutions. So I think efforts are made. No system's perfect, but I think that everybody works in the systems doesn't want patients to be harmed. They don't want the errors to be there. Everybody has the same goal. So I just think that human errors happen, and they're going to continue to happen. We just have to try to mitigate and prevent as many as we can.
Thank you.
And another question that's come in that looks like it's got quite a few votes, and Al, you might be the best one to help provide guidance, but also along with our legal friends, specifically regarding how medications given during bypass by a perfusionist but not directly ordered at the time. What's the best route for documentation to keep everybody safe in their own practices?
And I'm going to throw right back at Christy and Deb, because I would be giving opinion more so than learned knowledge. So please, Debbie and Christy, if you would address that. That's a very good question, one that we deal with as perfusionists. Only a quarter of the states I'm aware of have licensed perfusionists. Most are non-licensed. So
I did have that question. So thank you for that clarity for our folks who aren't perfusionists, that it's not 100% across the board.
From my perspective is there are, in some places there are standing orders, so the doctor has specific preferences. The other thing is that you document, if the doctor says I need this med, or you're giving meds to alter the blood pressure and the plasma light and this, that, and the other, whatever you're using, you have to document it appropriately and make sure it's accurately documented. And if there's any question about the dosage, or there's a problem, or you're running out of because some errors get made when there's medication shortages, or you don't have the right bag and you're having to mix things. It's really just about paying attention and documenting that why you're doing it. It's in response to this, given in response to this.
So if it's a standing order, is it as simple as making sure that is what gets documented like that then, Debbie? Like specifically making the statement that this is a standing order?
Well, if there's a standing order, which is often the case in perfusion, it's my understanding, that is an order. So the fact that there exists a standing order You can say as per standing order, gave this. Yes, you certainly can reference the fact that it's a standing order. If they allow you to use abbreviations, if you're allowed to use SO, if it's an approved abbreviation, don't start making up your own. But you can reference as per standing order, this given, that covers you. But make sure that you're familiar with the standing order and that you're looking at it and that you're not just, you know, if the standing orders are different per physician, or if you work in more than one institution, make sure you understand what the standing order actually is. And if you need something more than the standing order, then you need to get a verbal order, you know, from the at least the surgeon, to the extent that he can give you the verbal order for the specific perfusion. And they likely can or would. If you have another question and if it's a, you know, it goes into whether it's a stat thing. Is it something that has to be done right away? But yes, if there's a standing order, that's the safest bet, and just make sure that you're being consistent with it. So that I hope that answers the question.
I think
so. Christy, here's a quick question on Vanderbilt. Was Vanderbilt punished in any way? You know, they published the 105 response to CMS, but you know, that could be lip service, even though you did say they did do a lot of those changes, which should have been in practice before. Did they get punished in any way for this?
There was no so-called punishment for Vanderbilt. The board didn't discipline them. CMS did threaten to take away their Medicare payments. Again, Vanderbilt isn't providing any comments on this. However, I imagine that, you know, probably any damage to their reputation has been a kind of punishment to them.
I guarantee you their settlement wasn't small also. Their confidential settlement wasn't small. Not that that's enough, it's not necessarily enough punishment, but the government didn't punish them.
Right. And then when you're thinking about criminally, I mean, you can criminally charge Vanderbilt, but then it's hard because there's not really a person. Is that right, Deborah? I mean, that's pretty complicated.
Oh, they're not going to criminally charge the institution unless there was specific knowledge by, you know, somebody that affirmatively did something. But I mean, it's possible that they could be at risk for accreditation. Maybe they have JCAHO coming and they're going to get a much tougher look than they normally would, and they might put them through their paces. Sorry, I'm getting bad time of the day sun glare. But they had to respond to that 105 pages of everything they did wrong, and I'm sure that they will be, you know, looked at again and inspected again. But
because it sticks out in my head about, you know, purposeful hiding of the, you know, asking for the lack of documentation of the overall error, that would not somehow constitute some heftier punishment on behalf of the institution.
When I first read it, I had the same response. I said, really? They have a supervisor who told her not to document? I thought that was going to be pretty egregious. But looking into it further, it appears as though the person who did that thought that there was going to be automatic documentation based on the removal of the medication from the AccuDose system. So that might have been an error. I think the failure to report is that's their biggest thing, because to me, that seems like it was a cover-up, because they fired her. They fired her and knew that this lady died as a result of this medication error. They had an obligation to report it, and they didn't. And that, to me, is what they could have gotten hit harder on.
Right.
I want to thank Mark Parker for that comment. Another one that Dan Rodriguez has brought up, and this is a good, valid question for Christy and Debbie. I'm not sure, Cheryl, if in the IOM realm you guys have the same thing occurring, but many times we as perfusionists sitting behind the heart-lung machine will be handed a medication from an anesthesiologist, and they'll say, "Here, give this." You know, what is there problems with that? You know, usually it's a physician, although it could be a CRNA, but, you know, we're handing a medication. You know, the previous question was, we determined to give a med during a case and standing orders are in place, but now you're handed a medication. Do either of you have a comment, or even Cheryl, on what should be done in that situation? Usually a syringe. These are usually.
I was just going to say, I'll say easy for me to respond quickly on the IOM front. It's not going to happen. And if it is, don't do it.
But, right, on IOM is different because you guys aren't giving medications.
Right.
If the perfusionist is asked to give and handed a medication by an anesthesiologist, they should first ask what it is, ask what the dose is, and they should document administered the medication provided to me by X person. This is what it is.
Debbie, just to follow that up, they're handing you a syringe with liquid in it, and it may have a label, may not.
So you have to ask the question. You can't be a potted plant. You have to say, what is this? I need to document it.
So there's trust that has to occur. But, we normally draw up our meds ourselves and have them, or they're drawn by a pharmacist. Here, a party behind a blue screen somewhere drew this up and handed it to us. It's a scary thought to think that somebody can hand you a syringe, a lot of trust there, and you inject it into an individual.
And sometimes it's hard to speak up, but you have an obligation to your patient. And the first thing the plaintiff's lawyer is going to ask you is, do you know what patient advocacy is? Yes. Aren't you responsible for being a patient advocate? Yes. How were you a patient advocate in this case? Did you ask a question, or you didn't ask one question? You didn't even know what it was. You just gave it. So that's how they're going to come at you. So you can't be afraid to ask the question. You have an obligation, you have responsibility. Sure, I'll be happy to give this, but what is it? I need to document it. Please tell me what it is. And then when they tell you, you write it down. Administered the medication, ordered and presented by whatever, and you put that down in your record.
I would guess, and this kind of ties in we have a couple questions specific to policies and procedures. I would guess that your policies and procedures would help guide exactly whether you could take that unlabeled medication and administer it. And I do think that that's important, perfusion, IOM, kind of anything in healthcare as far as policies and procedures go. When is it okay to, or what do you do if you have to deviate? This is kind of a two-part question, getting two questions in the queue out. What do you do to deviate from those policies and procedures? And what happens if there aren't any policies and procedures?
Two-part is true.
Yep.
So you're absolutely correct. So it's very possible that I wasn't mentioning that there could be a specific policy and procedure. The other thing is that why isn't the anesthesiologist giving it themselves? Because they have access, they're giving medications all the time. So I don't understand why it would be given by a perfusionist unless it has to go through that route somehow, because I don't know enough about the details of that. But yes, I would think it's pretty odd or unusual for them to hand you something unless there's some clinical term of art or art form in applying and administering some medication via the perfusion system, as opposed to simply injecting it the way they normally would, inhalants or IV meds or IM meds for that matter. But and if there's a specific policy says you never can do this, then you have to never do this. You have to say, I'm sorry, I'm not allowed to do that. And then if you get into the problem is that if you have a patient's life on the line and the anesthesiologist is telling you, I don't know, the line's blown up here, I don't have access right now, and the patient needs this medication, and the patient's in jeopardy, then you're not going to let the piece of paper tell you that you can't save the patient when the doctor's telling you need to do this to save the patient. So from that standpoint, you just need to document very clearly why you did it, who's told you, who gave you the medication, who told you there wasn't access. You asked if they could wait until they could get access. They said, no, it's urgent for patient safety. And that's why you did it. So just document what you need to do.
Great, that's super. Hey, we're just about out of time, but I want to ask all three of you a very quick question in regards to clinical practice guidelines. These are used by perfusionists, they're used by physicians, they're used by neurophysiologists. And of course, they run the gamut of having something we should do or something we shall do, mandatory versus, suggesting. Can any of the three of you comment on their place? We talked about policies and procedures, but these clinical practice guidelines are really coming forward from the Institute of Medicine, supporting them for so many years. What place do they have, or is everything local? Is the standard of care in Philadelphia different than Tennessee? So Christy, I'll begin with you. Can you comment on that? And then we'll go to Cheryl and Deb.
Sure. Well, from a corporate perspective, I mean, they're called guidelines for a reason. They're guidelines because, in the best circumstances, or, in your cookie cutter case, like, this is what you should do. However, perfusionists, IONM, any clinician has had, substantial education, and the guidelines can't cover every single event or case that may come up. And so you've got your clinical judgment that is more important to use in those circumstances.
Thank you, Christy.
Yeah. And that's exactly how we present the clinical practice guidelines on the IONM side, in particular within specialty care, as well as, some of my work in broader and other professional societies as well, is to remember that first and foremost, they are guidelines, and it's never a replacement for your clinical judgment as to what's happening for that patient on that day, in those given circumstances. And the other component that we utilize them for is to give you something to document against, right? So if you have to, go outside of the clinical practice guidelines that are accepted amongst your group, then you have something to say, I didn't do this because of X, Y, and Z. And then you can follow that thought process throughout the documentation and for why you made the decisions that you did to help keep the patient safe at that point in time. So I think that's the other way that we kind of look at that. As you guys are and we are in the outsourced environment, sometimes one of the concerns is that your specialty care guidelines or your practice's guidelines are maybe different than the institution's guidelines, and then that really becomes making sure that communication is really taken into account on that front, and making sure that everybody's on the same page with what's going to kind of how to document at that point in time.
Right. I was going to say really quickly, there definitely has to be communication if there's a difference. They're both Christy and Cheryl are 100% correct. The guidelines are guidelines, but also understand that the guidelines are developed on evidence-based medicine. They're not putting out guidelines for you that don't have rational scientific basis. They're not pulling them out of the air. So for the general rule is those guidelines are there to guide you because that's what is thought to generally be accepted standard of care. And the standard of care in medicine today isn't really local, to Al's point. It's not Philadelphia's one way and Wyoming's another way and North Dakota's another way. It's the scientific knowledge in the field. Yes, there can be some slight differences, but it's all based on evidence-based medicine and evidence-based practice. So when there's an exception, as Cheryl said, you need to be careful to document. You discuss this with the doctor. You discuss that, you'd like, this is under the guidelines, we would do this, and they specifically want you to do X. And if you think X is a problem, then you have to decide and maybe move it up the chain before you actually implement something different.
Well, guys, this was wonderful. I want to conclude by, first of all, thanking all of the individuals who participated online through the Q&A or just stayed the entire time. We still have almost the same number of people as when we started. This was a thrilling subject area. Christy, Debbie, you did a wonderful job in presenting it. And Cheryl, thank you so much. I think I'm going to go ahead and commit to another discussion on this, and perhaps we'll do mainly a Q&A instead of a presentation to begin, or a very short presentation, because the questions that were provided are really very, very important. And I apologize for not getting to some of them. Before we conclude, I want to thank, I want to draw our attention next month. We're going to be hearing from Dr. Jacobs, one of the founding members of the STS registry, one of the most published physicians in the history of cardiac surgery. And he's going to talk on the STS database, what is new. And so I'd like to conclude with thanking Christy and Debbie for their wonderful presentation and their discussion. Cheryl, you're an excellent co-moderator. We're definitely going to have you back on. Maggie, thank you so much for your logistic organization, as you always do such a phenomenal job. And I wish everybody a pleasant evening, and again, have a wonderful time, and we'll see you on the next webinar.
Thanks, everybody.
Thank you.